Welcome. This is Lydia, sign name L. Brown, pronouns they, them. I'm a youngish East Asian person with short black and teal hair, wearing a dark blue speckled shirt and a jade necklace. I'm in a blurred room. I am the Director of Policy, Advocacy, and External Affairs for the Autistic Women and Non-Binary Network, and I'm really excited to welcome you this evening to the latest installment in our Liberating webinar series, tonight addressing disability justice and legal advocacy. As we get started, I'd like to note that we have captioning available. You can access the captions by clicking the CC button at the bottom of your screen, and you may choose to show subtitle or view full transcript in order to follow along. We're also streaming live to Facebook, and you are welcome to participate in conversation through the comment section on Facebook or through the chat box here, where you can send a message to everyone or just to our panelists by using the drop-down box. Please feel free to share your comments and questions throughout the evening. If you are on social media, we welcome you to post about our event with the hashtag Liberating Webinars. If there are any issues with access at any time during our event, you are also welcome and encouraged to let us know in the chat so that we can pause and attend to whatever access issue is occurring. Tonight, I am really excited to introduce three friends and colleagues. First, I'd like to introduce Jamelia Morgan. Jamelia is an award-winning and acclaimed scholar and teacher, focusing on issues at the intersections of race, gender, disability, and criminal law and punishment. Her scholarship and teaching examine the development of disability as a legal category in American law, disability and policing, overcriminalization, and the regulation of physical and social disorder, and the constitutional dimensions of the criminalization of status. Morgan joins the University of California at Irvine Law School from the University of Connecticut School of Law, where she was Associate Professor of Law. Professor Morgan has taught at Brooklyn Law School, New York University Law School, and Yale Law School. Prior to Professor Morgan's academic career, she was a civil rights litigator at the Abolitionist Law Center and worked to end the use of solitary confinement in Pennsylvania state prisons. Professor Morgan was also an Arthur Liman, Liman, Fellow with the ACLU's National Prison Project, where she focused on the impact of prisons on individuals with physical disabilities. Prior to her fellowship, she served as a law clerk to the Honorable Richard W. Roberts of the United States District Court for the District of Columbia. Next, I'd like to introduce Prianka Nair. Prianka is the Assistant Professor of Clinical Law and Faculty Director of the Disability and Civil Rights Clinic. Prior to joining the faculty at Brooklyn Law School, Professor Nair worked as a public interest attorney at Disability Rights New York. She conducted abuse and neglect investigations, focusing on access to services in correctional facilities across New York State. She's also litigated cases and led policy changes to achieve equal rights for persons with disabilities. Her litigation included cases involving violations of the Americans with Disabilities Act, the Individuals with Disabilities Education Act, and the 14th Amendment. She has also represented clients in all aspects of guardianship and related proceedings in state and federal court. Professor Nair completed her Master's of Law at Columbia University, where she was a Kent, K-E-N-T, scholar. Prior to this, she worked as a solicitor representing the Australian federal government as the Australian Government Solicitor. And last, but absolutely not least, is Britney Wilson. Britney is an associate professor of law and director of the Civil Rights and Disability Justice Clinic at New York Law School. Remind me not to mix up the names of your two clinics. Be very easy to do. Before New York Law School, Britney was a staff attorney at the National Center for Law and Economic Justice, where she litigated disability rights and excessive fines and fees case. Before that, Britney was a Bertha, B-E-R-T-H-A, Justice Fellow at the Center for Constitutional Rights, where she litigated discriminatory policing, abusive immigration detention practices, and economic justice cases. Before that, Britney was a Marvin, M-A-R-V-I-N, M, Karpatkin, K-A-R-P-A-T-K-I-N, Fellow in the Racial Justice Program at the ACLU, where she litigated a range of racial justice issues from the school to prison pipeline and the criminalization of housing and inclusion in higher education. Born with cerebral palsy, Britney has written and spoken extensively about disability and the intersection of race and disability, including as a poet and creative writer for various outlets such as The Nation magazine, Long Reads, This American Life, and HBO's Brave New Voices. Welcome, and thank you again so much for joining us. I also will reiterate for folks that have just signed on, we do have captioning available and we encourage you to join the conversation. Please feel free to share in the chat where you are joining from and what you are excited about learning tonight. To start us off, I'd like to ask if the three of you would give us a clear definition of what disability justice is and how it differentiates from disability rights, since that's the term most people tend to be a little more familiar with in a legal advocacy context. Jamelia, why don't we start with you?
Thanks, Lydia. It's really an honor to be here with you all and my co-panelist, two people that I've learned from tremendously. To get us started, I have a few thoughts. So for me, disability justice is an analytical tool for pushing back against law's harms, for understanding and analyzing how law has contributed to the oppression of disabled people. I am informed by the organizing around disability justice, and in fact, why it's so cool to be here. You know, folks like Lydia, Talila Lewis, Dustin Gibson were a part of my thinking of how to contest systems of oppression like our policing and punishment systems through a lens that considers racism, ableism, heteropatriarchy, settler colonialism, and in ways that doesn't remove the law's responsibility in contributing to those harms. So, though I came out of legal practice with an interest in using law to, again, challenge the oppression that these systems were generating within disabled communities, I don't only think about law. I, in my work, am very much inspired by and in community with organizing and mobilization against the prison industrial complex, because I see abolition as necessary to the liberation of disabled people. So for me, disability justice is a tool for understanding social problems. It centers the experiences of disabled people, including disabled people of color, queer disabled people, trans disabled people. And it does so in a way that's rooted in movements and a radical project of eradicating all systems of oppression in society. And I'll stop there, just some broad framing, and I'm happy to talk in more detail later on.
This is Lydia, and could you quickly give us a visual description of yourself too?
Apologies for not doing that earlier. So I'm a Black woman. I'm wearing my nicest camel-colored blazer with a striped blue and white shirt. I did my hair in 2 goddess braids, and I have hoop earrings.
This is Lydia. Thanks so much. And I love that they're goddess braids. I feel like you've just sent like an entire message, right, to the kind of work that we're doing and trying to encourage and support other folks in doing. I'll turn to Britney next. If you would talk a little bit about what disability justice is, help us ground this conversation.
Sure. I'll start with my visual description so I don't forget to do it. I'm also a Black woman. I wear rectangular Black rimmed glasses. I have my hair in black twists, and I have a white sweater on, and I'm sitting in front of a yellow wall. And very similar to what Jamelia said, I feel like the rookie on this all-star team on this panel, because I've read and been informed by a lot of Jamelia's work and Priyanka's work as well. I usually steal a combination of Jamelia and TL's definition of ableism when I teach it to other people or disability justice. So I'll amend TL's definition and say it's a system that ranks people's bodies, that puts value on people's bodies. That's what ableism is, and disability justice works to dismantle that effectively. It is analyzing how ableism informs every aspect of society and social justice, basically. So how it informs racism, how it informs class, how it informs gender dynamics, and every other ism that you can think of. And that's my short definition of what it is.
This is Lydia. Thank you for sharing that and just uplifting the name that both you and Jamelia cited is Talila, Talila, Lewis, Lewis, whose name is also TL, which is also TL's sign name. And I put that in the chat along with TL's working definition of ableism. Priyanka.
Yeah. Hi. So I'm a woman of Indian descent. I've got long black hair, which I have especially washed for this panel. I am wearing a black blazer and a black top with some spots on it, white spots on it. I think to go back to the part of the question that you asked, I mean, my panelists have given a really great theoretical underpinning of what disability justice is. And just to go back to your question, Lydia, with respect to how is it different from the disability rights movement, which is what I think I can contribute here. The disability rights movement was momentous in that it did culminate in changes to the way that we think about disability, and it culminated in the ADA, and prior to that, the Section 504 of the Rehabilitation Act, really important civil rights changes. But the disability rights movement, and here I'm really borrowing from Patty Byrne, who was the co-director or the co-founder of Sins Invalid, who talked about how the leadership of the disability rights movement was single issue identity based, and its leadership was historically centered on white experiences, and its framework left out other forms of oppression and the ways in which privilege could be leveraged at different times and for different purposes. It centered people with mobility impairments and marginalized other kinds of disabilities. And it really presumed that people would be able to access their rights through a legal or civil rights framework. I think the disability justice movement complicates that idea because it recognizes that people with disabilities come with multiple identities, which results in multiple forms of prejudice and or oppression, as well as privilege. And so really tries to think about the disability movement in a much more nuanced way, taking into account all of those other factors and the way intersectionality plays into what, as Britney was saying, plays into ableism and how it manifests. So those are my thoughts.
This is Lydia. Thank you all for sharing that. I will add that when I talk about disability justice and rights and what the distinction is, I really just try to make it simple. That disability rights is fundamentally about changing law and policy to improve the social condition for disabled people. And disability justice recognizes that while rights-based work is necessary and important, it is also insufficient. We've had many of these laws, sometimes for decades, and yet ableism persists. Disabled people continue to have higher rates of unemployment, impoverishment, homelessness, and to experience higher rates of sexual violence, of police violence, and incarceration than non-disabled people do. And so disability justice asks us to look at societal and cultural conditions that enable those harms and that underlie those systematic inequalities and injustices that simply doing legal and political or policy-based advocacy will be insufficient to fully or completely address. Now, we talked a little bit about this, so kind of spoiled it a bit for folks who are joining, but I would like to start, with the negatives and then move to the positives. So I'd like to ask each of you to share what are some of the ways in which, especially people who are doing legal advocacy as lawyers, as law students, or as legal volunteers, or folks who are in the policy realm, fail to incorporate disability justice and what the consequences of those failures are. And for this one, let's start with Britney.
Sure. I think I went most of my career so far without really hearing the word disability unless I was the person who brought it up. That's part of the reason I've made some of the career changes that I made recently, because I've said a lot that as a Black disabled woman and attorney, I felt like there was sort of no country for me. I'm a civil rights attorney. I dealt mostly in the realm of racial justice cases and the Constitution and Section 1983 in terms of like legal statutes. It was only in the last 2 or 3 years that I actually worked on cases specifically on behalf of people with disabilities. And I chose to be a civil rights attorney, sort of naively assuming that disability would be included among the social justice issues that we worked on, but repeatedly found myself in social justice spaces being the person to say, and people with disabilities, and people with disabilities. And I also sort of intuitively felt, just from my own experience as a disabled person, that the disability rights space wasn't really the space for me as a Black woman. So I felt like there was nowhere for me to go. So I think that's one of the major ways that the disability rights space and the social justice space as a whole fails, because the two arenas sort of operate separately and don't really understand how they're informed and inherently linked. But I think also, just if I can be real, another way that they operate, I think they perpetuate a lot of the very same forces that they're supposed to be fighting against. And I think that's true of all public interest spaces and in all spaces in general. But I think particularly in social justice spaces, you can't fight against an issue while also being ableist, for example, while also being racist. You can't effectively fight those issues if you don't understand how they're linked. So I think there's a sort of substance missing from both arenas because they don't work together enough and they don't understand how they inform one another. But then there's also a practical hypocrisy that exists within the arena as well.
This is Lydia. Thank you for sharing pain really personally of always being the one to say, yeah, but what about disability? But then in disability spaces, and I'm sure you've all experienced this too, I'm always the one saying, well, we need to talk about race. And people are like, no, we don't. It's not relevant to talk about disability. And I'm like, but it literally is, because disabled people of color literally have worse outcomes in all of these same areas than white people with disabilities. And that's literally borne out even by the US government's own statistics. The US government doesn't have an incentive to try to reveal those truths. And yet the US government's own statistics reveal those inequalities. Prianka?
Yeah, I do a lot of guardianship work. And one of the things plaguing states are looking at reforming guardianship statutes, thanks to Britney Spears and kind of the fact that people are now talking about her and conservatorship in general. I don't think it's any accident that it's because it's Britney Spears and she looks a certain way and occupies a certain role in society. But I will say that in general, it's very funny as a disability rights advocate to be, or a disability advocate to be looking at conservatorship critically now, or seeing how people are now looking at conservatorship and guardianship more critically. The fact is that we've been focusing on this issue for a really long time, and yet there are no real national statistics about who is being placed under guardianship. Courts don't know how many people are placed under guardianship, and they don't know who is most impacted by guardianship and whether certain segments of the population are more impacted than others. And if you are looking at a way of reforming guardianship statutes, you really need to be able to understand how ableism interacts, or disability interacts, with other identities. To be able to come up with solutions that focus on what are the structural barriers that prevent people from accessing supported decision-making versus guardianship, or who is most impacted by having these regimes, guardianship regimes, that are just so very punitive and rob people of their civil rights. So that's just an example of how failing to look at disability justice really compromises the way legal systems are reformed, because we simply do not understand the scope of the problem and who is being impacted by the law. So that's just a concrete example that I wanted to throw out there.
This is Lydia. And Jamelia?
This is Jamelia. Just to pick up on Priyanka's helpful point, I'll give another example, and I think this also identifies, Brittany, something you were referring to as well, but the erasure The erasure that happens when we, as advocates in disability rights movements, prison rights litigators, abolitionists, police abolitionists included, don't think intersectionally. When I was practicing as a prisoner rights litigator, what I found is that even though the people we served, our clients who were incarcerated, had disabilities, some identified as disabled, that particular experience was not centered in the advocacy. Our briefs, I wrote about this in an essay called Ableism in Prison Reform Litigation, but our briefs were reinforcing ableism in the way we were describing the harms that our incarcerated clients experienced in torturous conditions like solitary confinement. We were reifying the kind of ableist description of disability that roots the problem that disabled people experience in their bodies and minds, and not in the harmful systems that are incarcerating them. And so I went through in that essay to discuss the various ways that shows up in pleadings by prison rights litigators who, by the way, aren't intentionally discriminating against disabled people, but the impact of what they're doing has longer term consequences for the movement. Another example would be with policing. Within disability rights, and this is changing, and I commend a lot of the disability rights organizations for moving in the direction of disability justice, particularly after the murder of George Floyd and the uprising. But what we tend to see is a failure to contest the category of criminalization, the category of criminal in the work around policing. So ceding the ground that some of these constructions where we see in many cases people actively seeking mental health services, people occupying public spaces, and being criminalized for their very presence. These people often are individuals with disabilities. And if we don't challenge criminalization, what we end up doing is finding a new way to criminalize disability in 2021. This is the ugly law version part 3, to reference Susan Schweik's incredible work. So all I'm suggesting is that disability rights, prisoner rights, and policing, sort of that community that's sort of now about reform and also pushing towards abolition, engage with the disability frame, engage and think intersectionally about disability so that their advocacy isn't contributing to the problem, so that the remedies that they seek aren't harmful, like training and ID cards for people with disabilities, which I identify as harmful because they're not getting at the source of the violence in the first place, the police violence or the vulnerabilities. And if anything, increasing the surveillance of disabled people in society. So lots more to say, but the erasures have caused tangible harms, and we need to, as disability justice advocates, push our colleagues to be more intersectional to redress these harms.
Yeah, two more random thoughts that just came to me. This is Brittany. I think also when we talk about the intersection of race and disability justice, people equate that with like diversity in the disability space. And that is not it either, right? It's not just about the fact that disabled people of color are disproportionately represented in all of these categories. It's literally about understanding how the structures and institutions of ableism and racism work together to influence everything in society, right? So it's not just about disabled people of color having higher rates of employment or being or unemployment or being in certain rooms or certain spaces. It's not about, coloring in the picture. It's about the systems themselves. And I think an example of that, literally yesterday, I saw someone tweeted an article about the MTA is now trying to, and I live in New York City. So the MTA is now trying to make more of its subways accessible. They're building more elevators after years and years of lawsuits and ongoing advocacy. And in order to build those elevators, they've passed some sort of city council bill that is giving private companies in exchange for donations to the MTA, additional air rights to build up high skyscraping buildings. And that's a particular issue in rapidly gentrifying New York City, especially areas like Brooklyn, which is where I'm from. So that to me screams an issue where we need to think intersectionally, because here you go, you're like, oh, I'm addressing the disability rights concern, I'm giving you more elevators. Yeah, but you're simultaneously displacing low-income people of color who are also, guess what? People with disabilities, right? So it's not just about more disabled people of color being in the room. It's about thinking about how these structures interact.
This is Lydia, absolutely. And I really, really am frustrated all the time by how often well-meaning people really collapse that message. They're like, oh, so you just want to talk about diversity. And I'm like, no, actually, that's literally not what I want to talk about. I hate that word and I don't use it because that's not the framework I'm operating from. That's not the issue that is literally taking people's lives, that is putting people's lives, health, safety, and freedom at risk. You can have plenty of people with disabilities, and you can even have them be queer people with disabilities who are of color, who are sitting in some table somewhere. And does that mean that we've done something to undermine the systems of mass incarceration, of impoverishment, the way that ableism creates medical discrimination, the ways in which ableism fuels intimate partner violence and family abuse and educational abuse, segregation, disabled folks? And the answer is it really doesn't. It really doesn't. Now, we spent some time talking about what some of the problems are that face people working in legal advocacy and related fields. I'd like to ask you what you see as the most important and helpful strategies for incorporating disability justice framework into doing legal advocacy. All three of you are teaching, and all three of you have also practiced. And all three of you come with lived experience, right? So you are part of this space from multiple vantage points. You bring multiple perspectives. What do you want legal practitioners to know and understand? What strategies do you want them to be using? What would make their advocacy more responsive to what our actual needs are as communities? Oh, and why don't we start this off with Jamelia this time?
Yes, this is Jamelia. I think that this question, Lydia, is super important. I think the theorizing that that disability justice is rooted in, informed by movements on the ground, should have an impact on legal advocacy. So how could that happen? I'm just going to talk right now about policing. I largely look at policing and prisons, so the constitutional dimensions of both. But there's obviously other areas of law that we can look at as well. I know folks like Natalie Chin and Prianka, you all have done work on the limits of the ADA, right, as a kind of a legal tool itself. But let's just think about policing. So strategies, the work that I'm doing now is working with public defenders to start thinking about how they can raise, sort of in motions to suppress, Fourth Amendment claims that capture some of the disability discrimination and subordination that their clients are experiencing. In recent work, I've shown that the Fourth Amendment, the grand constitutional amendment that's supposed to protect all of us from government intrusion, has pretty much erased disability as a way of thinking about individuals that face the harms of the state, which is to say, the Fourth Amendment cares not at all about disabled people. I show this with respect to the fact that literally non-normative behaviors and appearances can be a basis for criminal suspicion under Terry. The police can intrude upon you, stop you, and if they find reasonable suspicion, put their hands on you, right? These are actual violations of bodily integrity. The Fourth Amendment says nothing about that, or doesn't at all scrutinize that as a basis to intrude on the rights of disabled people. And I'm thinking of Elijah McClain. I am thinking in particular of Ricardo Hayes, And I'm thinking of the pathway that the Fourth Amendment laid out that led to the violence, the deaths in Elijah McClain's case that those two people experienced. I also talk about consent searches. I talk about consent or the point in which you actually have rights, not taking into consideration disability at all, in particular intellectual and developmental disabilities with respect to one's voluntary consent to a search by police. I also talk about use of force in that paper. And so one of the things I just want to stress is that when we think about legal strategies and incorporating disability justice into our advocacy, public defenders, civil rights attorneys, in particular, need to adopt a critical analysis of the very laws that they are litigating in, the very space that is. And that is a basis for, yes, legal remedy, but also a reduction in the harms that we're seeing on the street, because we know with, in particular, policing and Fourth Amendment doctrine, that it has an impact on police on the ground. In fact, it's a race to the bottom. Whatever low floor the Supreme Court sets in terms of the constitutional standard will be what police departments do. So it's a very cynical view, admittedly, but it is a harm reduction tool. Now, towards abolition, I don't recommend training. I maintain that the law will continue to criminalize on the basis of disability, and our only remedy, one of many, is to abolish the way that we think about policing, that policing will function in the way that it's intended to function. And again, more work on that. I don't want to take up too much time. I think you all can tell I get very passionate about this, because I think as has been crystallized on this panel, the harms are real. People are dying. And that's all I'll say. But again, critical analysis has to inform your advocacy. We've got to advocate on behalf of disabled people, including low-income disabled people of color in particular, who are being pushed out of American cities right now because of a lack of affordable and accessible housing.
Thank you. And Prianka, I'll turn to you.
Yeah, I've been thinking very hard about this because part of my role is also to teach a clinic. So I teach students who are undertaking representation of our clients who are people with intellectual and developmental disabilities. And some things that I try to introduce and that I think are important for students to think about are recognizing that their advocacy does not take place without context. That in fact, each client comes with their own experiences and from their own context. So really trying to push the principles of client-centered lawyering, where you look at the whole client and everything that is there in their lives and what their goals and values and aspirations are. And you really seek in your representation to do them justice versus just seeing your client as a legal problem. And that can sometimes a legal problem that should be solved, which I think is what you learn from law school, that, legal situations are purely legal and they're not actually about people working in contexts. And so something that I think is really important for students, law students, to get from the beginning of their practice is the recognition that their clients really are the experts in their own lives. And as lawyers, you're sometimes taught to believe that you are leading the movement. But I think when you think about disability justice, you need to recognize that it's people who are most impacted by discriminatory laws and policies that really should be listened to with respect to how to reform those policies, because they are the ones who will ultimately bear the brunt of them. So it's an exercise in humility for a lot of law students who might not have really been introduced to that idea, because law school is not really about that. And then another thing that I try to kind of get my students to think a bit more critically about is rejecting the primacy of that idea of independence and autonomy and self-reliance, which is something that the disability rights movement has focused on. And while independence is a goal for some people with disabilities. Interdependence, I think, is a much more complicating idea and also a more realistic picture of how people live. Everyone, to go back to the guardianship context, everyone relies on other people to make decisions, especially important decisions in their lives. Everyone requires support and help to make those decisions. And so I try to get students to really think about the complexity of their clients' lives, and to think about what are their sources of support? What are their goals and aspirations? Who are they as people? What is it that has affected them? And a final thing that I will say is trauma-informed lawyering. The panelists, both Britney and Jamelia, and yourself, Lydia, have spoken about the trauma that people with disabilities experience, more likely to be victims of non-fatal but violent crimes, more likely to be subject to forms of abuse that aren't typical, for instance, having medication or aids or services withheld from them, more likely to be incarcerated. So it's very likely that people with disabilities come to our practice being traumatized. And if you do not bring a trauma-centered kind of understanding of that experience, you risk re-traumatizing. You haven't fully internalized their experience. And I think that's an important practical tool that I think about.
This is Lydia. Thank you for sharing that. Oh, and Britney, I was about to say that we'd love to hear from you too. And there you are.
I was just going to say that Prianka stole most of my answers. We were thinking along the same lines. I think especially on the professional humility piece and teaching students that it's not your job to know all the answers. Actually, you probably don't know all the answers, and the person that's experiencing the thing does. And I think that is a principle of disability justice, right? Is leadership by the most impacted, and actually getting people to recognize that because I think that saviorism manifests itself in particularly unique ways in the disability rights space, in particular because there's sort of an assumption that your client needs your assistance in a different way. So I think teaching people and making people understand that people generally know what they're experiencing, and our job is to listen to them and to work with them to come up with solutions to their problems, and also to not be afraid to challenge the status quo, because we're talking about the law, and the law maintains itself. It literally operates on the principle of stare decisis. What you do is based on what has already been done, and what it means to actually challenge that and push things forward, because if we don't, we're not getting anywhere.
This is Lydia. Thank you so much for sharing that. And, I just want to talk a little bit too about how sometimes, especially younger folks, can feel really frustrated because they think there's so many issues to be working on. What can I focus on? What can I actually do? And then they feel overwhelmed and they shut down because it just seems too big, too huge. Like, I don't know enough. I don't think I'm gonna know enough. I don't know how to work on the 80 million different things that plague the lives of disabled folks. And simultaneously, I hear a lot from older folks who say, look, I've been an advocate for 30, 40, 50 years. And I don't think that, there's anything else I need to know. I know everything. And I think that, we can recognize that that's not necessarily true in either of those cases, that being a young person doesn't mean you can't participate in the work or contribute to the movement. And being an older person with more experience, more years doing work doesn't necessarily mean you don't have something else to learn. But what would you say to folks in either of those positions who are coming to this thinking there's just so much, what can I actually be working on? Or who are coming to this thinking, there's nothing for me to learn. I know everything there is. What would you say to them? And Britney, let's go back to you to start with.
Yeah, I was going to say, I think I deal in both of those spaces pretty frequently. To the young people, to the people I teach who are like, where do I get in? Where do I fit? I'm a big Derek Bell fan, and to oversimplify his theory of racial realism, he says none of this is ever going away, right? And he says your goal isn't to fight to think that you are going to rid us of these structures and systems, but it's to fight against the latest iteration of it so that it doesn't swallow us all up. And so I tell that to my students, like we read that essay, it's one of my favorites, and I tell them that there's value in the fight itself, even if you are not solving the whole problem, saving the universe. That isn't the goal. There's value in the fight itself, and it actually helps when it at least helps me feel less overwhelmed when you think you've won something or you think you've gotten a victory and you see it's a problem manifest itself in a different way, and then you're upset because you're like, I thought I solved it, when you realize, no, actually your goal is to fight, and there's value in the fight itself, and that is what you should be doing, is finding that place where you can contribute and doing the best you can there. And in terms of like your interests, pay attention to the things that make you excited, and to the things that you're passionate about. And on the flip side, to the older people, I'm a youngish new law professor, and also sort of a mid-level attorney who often works with older attorneys who've been doing things for many years and who think that means that I don't know anything and they know everything. And, I can recognize that I don't know everything. And I admit that, right? I think I'm pretty good at admitting, I'm like, I don't know. What do you think about this? And I just ask for the same humility from other people, everyone has different life experiences. Just because you've been doing something longer doesn't mean you do something better. And we approach things from different entry points, and there's value to all of those things.
This is Lydia. Thank you so much for sharing that wisdom. Prianka?
Yeah, I think what doing civil rights work is frequently an uphill battle. Doing guardianship work, which is a lot of the practice of our clinic, is also an uphill battle, because you are sometimes going against the grain of what society has been thinking is the right way to manage the needs of people with disabilities for a really long time. So for my students, who I think are a lot of the young people who really feel overwhelmed by the challenges of the system and really struggle with the fact that resolving this particular case in front of this particular judge does not change the system as a whole, it's helpful to get them to think about how, even in their petitions, and this goes back to something that Jamelia talked about with respect to advocacy in prison, Eighth Amendment claims, to think about how they can not be ableist in the way that they write their petitions, in the way that they approach the law and our clients, and present the court with a very nuanced view of the individual that really emphasizes the way in which they navigate the world with their disability, and really encapsulates everything about that person that indicates that their disability is not the only or the essential feature of who they are. And it's helpful, even if you know you're going against the grain, to introduce into the court a dialogue about the structural harms that result in people being treated a certain way by the law. So, for instance, when a lot of my clients are put under guardianship because of presumptions about their ability to make decisions as people with disabilities, as presumptions about capacity when they have disabilities. And some of them are very young people and, may not have had the opportunity to make very many decisions, but that's because of immaturity that comes from youth, and not necessarily because of a lack of understanding stemming from their disability. Their disability is not the problem there. So raising with courts that there are other reasons and there are other factors that go into making decisions, for instance, and that you need to introduce that complexity into the way the court thinks about things, there's value in doing that, because eventually that does enrich the conversation. So with my students, it is one case at a time, but you are thinking more broadly about the way in which this particular case has come to be because of certain structural limitations in the way that we conceive of the law. And with older people people who've been doing this for a long time, I would just say that I learned so much from my students and from their experiences. I think, they've come to law. Some of them are more professionally mature than others, but some of them are not as professionally mature. But with all of them, they come with a perspective and a freshness of perspective that I really don't think should be discounted, because they can profoundly change legal strategy. And I'm sure this has been your experience as well, Brittany. Suddenly realizing that your students have thought about things in a completely different way than you have, and actually possibly it was a better way. So I'm always very careful to not discount that perspective.
This is Lydia. Thank you for sharing that too. And Jamelia, I'll turn it to you for comment on this, and then we'll transition to take our questions.
Terrific. This is Jamelia. So I'll just add a couple other things, because I think, Brittany, your invocation of Derek Bell, right on. I sit in that tradition. Critical race theory, the Black radical tradition, has really kind of inspired me to keep this beautiful struggle going. Prianka, I think the discussion of clinic and how you facilitate kind of community within the clinic, it reminds me of what sustained me through law school, right? The work that we were doing as a collective sharing and knowledge building, and engaging our clients in that process was, for me, transformative. And it kind of emboldened me, I think, to kind of pursue law in a more radical way. And what I would add is, when we think of both sides, I don't know if I would say age is what's causing perhaps an unwillingness to want to think about some of these issues critically and engage with disability justice. Let's say if you're a longtime disability rights advocate, or if you feel overwhelmed as someone sort of new. But what I find is, like, being in community sustains you. It gives you kind of a purpose, and it gives you an opportunity to connect with folks that are sharing this experience of struggle with you. It reminds me of what, Kaite Davidson would talk about, like this disability solidarity idea. From what I've heard, I didn't have the pleasure of knowing Kaite, but I'm reminded of that praxis, this disability solidarity within disability justice that is rooted in love. And so I think it's very important for us to think about sustaining practices and to think about those that came before us, who were very much, again, to reiterate what Brittany said, very much committed to the long haul, but able to sustain themselves because they were in community. And so I just want to remind us of that. And I guess the last little piece is in just this engagement with study. And it doesn't have to be through books. But I think it has to be in some way, for one, connected to community, but two, connected to what is going on, and connected to understanding that theories of change are going to be the product of experiments. This is Miriam Kaba's book, right? Experimentation is going to get us to the liberatory future, the abolition future, the disability justice future, that I think we need to respond to all of the harms that we discussed.
This is Lydia. I love Mariam Kaba's work, and I learned so much from what she has done. I want to take a moment of pause just to appreciate the three of you for sharing so much tonight, and recognize that we have a few questions that have trickled in by Facebook and here on Zoom. And I'm going to ask a couple of those questions to you in our remaining time. So we have an anonymous question who says, I am wondering about the panelists' thoughts on embedding concepts of disability justice in the law school curriculum. I'm in Canada, and our faculty is really just starting to think about how to engage with these ideas in the curriculum. Any advice about how to move forward? and what potential pitfalls to avoid? Anyone can take this question.
I'll just offer a quick response. So I have an short essay coming out in the Journal of Legal Education, where I talk about how disability can be incorporated into criminal law and criminal procedure, and invite discussions on incorporating disability justice through that framework. One thing to think about is the way that we teach these traditional, air quotes, to connote traditional should be challenged. The way we teach these traditional courses certainly erases disability. And so there's ways to incorporate it, not just to reinforce pathology. So in criminal law, not just talking about the insanity defense, but contesting that as that framing, contesting or introducing ideas of the criminalization of disability, as I have talked about earlier. In constitutional law, I mean, we don't necessarily center Clyburn, but Clyburn is an important case for thinking about tiers of protection under the Equal Protection Clause, tiers of scrutiny, that is. So I guess the answer is take what you've got and eliminate the erasure by just centering what is being ignored. And I have specifics on how to do it, at least with the American curriculum. Not totally familiar with Canada, but I suspect that it's already there. It just needs to be surfaced.
I would just add, and I think that's excellent, Jamelia. I think the erasure can be fixed by centering that experience, by focusing on disability and seeing actually how it's a theme that runs across all of these different like traditional law courses and traditional laws. The other thing I would say is don't exclude the voices of the disability community from the curriculum. If you can incorporate people who are willing to share their experience and so that and have and share their perspective on how laws have impacted them, that is a really valuable piece of this education. And of course, you should compensate them for sharing their experiences and their views. But that is something that is really valuable for people to hear directly from those most impacted.
This is Lydia. Thank you for sharing some of your thoughts on that. I'm going to move to a question that comes from Alaska. Alaska says, thank you for sharing your expertise. I'm curious to learn more about the panelists' experiences of pushing for disability advocacy in academia, and if and or how they dealt with pushback from administration and colleagues. How has this informed the way they interact with students who approach them about potential accommodations? I'd also like to know if they have any advice for disabled people of color who encounter prejudice from university disabilities offices themselves, or even during the admissions process. And anyone who'd like to address that is welcome to.
I mean, I can't really speak to the first part just yet. I'm just in my first semester, and I don't think I have encountered that just yet. The second piece, I have lots of thoughts about being a Black disabled student battling administration. I don't have a lot of good advice. It's just the constant battle. I think find your allies. That's really important. Document everything as much as you can, and try to sustain yourself. I hate to say pick your battles, but from my experience, it can be a long haul.
This is Lydia. Does anyone else want to address that question, or should I just move to the next one?
I mean, I think universities have a lot of work to do with respect to how, especially law students, the law schools are not spaces that are especially diverse. And it is a profession that could benefit from a multiplicity of voices, and having attorneys with disabilities is critical to having a robust and conversation about the law. So I really think that, yes, it is a challenge, and it is something that we need to find a way of promoting the voices of students with disabilities who come seeking help. I will say that, my response so far has been unsatisfactory, in that I try and address it within the clinic to the extent that I can address it, and provide accommodations for the students who speak to me. But I have heard that it is a challenge, and it is definitely something that we need to look at. Academic institutions really need to be thinking about who they support and how they support them.
I'll just add to what Prianka and Britney have shared. There is organizing happening to address this issue. It is systemic. Ableism is pervasive in legal education. What I'm aware of is the National Disability Law Students Association and the incredible organizing they're doing to help students get the accommodations they're entitled to, and to push law schools to go beyond that low floor of a legal standard, an important yet not sufficiently high standard. As an instructor, I teach disability rights. For me, my goal is to create an inclusive learning environment that accommodates learning styles, ways of existing in the space, physically, mentally, emotionally. And so I have a set of practices that I've worked on to try to do that. I've also been a part of a group, law professors with disabilities. We're focusing in on some of the questions with respect to hiring and the process and the exclusions that happen in that process. And I'm happy to talk more about offline about how we're supporting law professors that are going on the market, as we call it, which is our hiring process.
This is Lydia. The next question that I wanted to ask coming out of our public comments is from Gabrielle. Gabrielle asks, I'm interested in how we can make the case for high levels of damages for our clients without playing into narratives of disability as tragedy.
I feel like you're best positioned to talk about this with your Eighth Amendment work, Jamelia.
Yeah, it's a tough one. When I think about, the structural conditions that have produced disabilities, for instance, and some of the clients that we represent are certainly examples of that. Jasbir Puar refers to it as debility, as a way not to totally stigmatize disability. But the question is certainly one that we have to think about. When I talk about the experiences with, subordination, harm, and discrimination, I focus on the systems. I don't center my clients and their particular disabilities as causing the problems that they're facing while incarcerated. But I think that there's, just to name it, there's some tensions within discourses that are requiring or advising people from historically marginalized groups to claim their disabilities in particular ways that don't take into consideration the stigma for doing so, that don't take into consideration the way that claiming could expose them to policing, to prisons, to a variety of harmful aspects of the way we regulate disability in society. In my class, I have education class privilege. I claim my disabilities for the students in my class that can't. That was a part of my political consciousness raising, in part because for a long time, having invisible disabilities made it so that I could skate by and I didn't have to be in solidarity. And so that's a personal choice. But like I said, if we live in a society where ableism and racism are so pervasive, as we've all been saying, there are some tragedies that produce debility. And I think we can name that while also not stigmatizing disability. And I guess environmental racism, poverty, etc. I mean, just to go back to Talila Lewis, poverty is a cause and consequence of disability. And so we have to talk about those systems while not stigmatizing disability. It's hard. And again, as a movement, we're still thinking this through. So I don't have any clear, this is the path, but it's an important question. I appreciate it because it's a tough one, but we have to think about this as advocates.
This is Lydia. Jamelia, did you want to add to that or want to pass?
Brittany.
Me? No, I don't have anything to add.
This is Lydia. I would add to that, not having been in a position where I'm trying to litigate and request damages, but thinking a lot about disability narratives, that speaking about actual distress and pain that a person experiences isn't the same thing as saying that all disability is tragedy. And as you probably know, and I know that we know each other personally, the person who asked that question, a lot of times those of us who are disabled do experience actual distress and pain that can be caused by different aspects of our disabilities. And we can talk about disability pride and disability power and not pathologizing disability at the same time as acknowledging actual pain and distress that can be caused or exacerbated by being disabled, as well as by ableism externally that affects our lives. And at least from my vantage point, I think it is actually unjust to expect that speaking about disability without being able to name experiences of pain or distress is the only way to respond to pathologization of disabled people. Because our real lived experience sometimes include experiences of distress or of pain. And so I would posit that describing such experiences is not necessarily upholding tragedy or pity-based narratives, but it is speaking truth about someone's experience. Our next question that I want to ask, and we have two more questions that I want to get to, and we just have about 5 minutes left or so. So I'll share what those two questions are, and maybe you can pick and choose which one you want to speak to. One from Nicholas is, to what extent do you think lack of diversity in disability rights is unique to disability rights? To what extent do other movements have diversity problems, and why is this? And then the other one is from Jenna. And Jenna says, it seems the definition of disability in college is expanding exponentially in the last 10 years. Does the panel feel eventually the term disability will be erased and instead individualized accommodation will be the norm?
I can think about Jenna's question. I'm not sure if the terminology of disability might change, but I do feel as a point to language and descriptions of disability and how to talk about disability, that's something Jamelia talked about, constantly educating yourself. And this is one of those things that one requires constant education about. Particular languages evolving and things that were not pejorative or offensive at one point in time do become offensive and pejorative, and it's important to keep your ear to the ground and recognize that. But to the question of individualized accommodations, I feel like institutions are slow to learn that individualized accommodations are meant to be the norm, that we are not meant to be making or creating flattened ideas about disability and what disability means, but really recognizing that it manifests in individual ways. I mean, we're coming to the first generation of people who have always had the ADA and always had the protections of the ADA. And institutions really, like higher education institutions, schools, prisons, they've been very slow to learn that lesson that actually individualized accommodations are required by the law. So that's just my thought in response to Jenna's question.
And in response to the first question, no, diversity problems are not unique to the disability rights space. It's everywhere. And why? Because institutional racism.
This is Lydia. We did just get one more question. If someone wants to address it quickly. This is from Al, who says, thanks for the panel. I'm wondering about how impact litigators in the criminal justice space should better pursue disability justice. This might be addressed in Professor Morgan's upcoming article, but I'm curious to hear if you have any advice similar to what you discussed for public defenders in terms of issues for impact litigators to prioritize, ways to better advocate for disability justice in our language, and critiques of statutes and systems, and anything else you think criminal justice impact litigators should be thinking about related to disability justice.
Thank you. So the question is a big one. Just to be brief, I would submit that we're going to see disability-based subordination at every stage of the criminal legal process. I have just talked about policing and prisons, literally the front end of the process, right? Getting observed and arrested, ticketed, et cetera, in the end. I'm starting a new project looking at advisement of rights. I do Fourth Amendment work. I work with the public defenders so that they can think about plea bargaining and the ways that disability-based subordination takes place in those processes. So it's not a cop-out to suggest that there's a way that we can think critically about disability and start through impact litigation, contesting the ableism that's operating at every stage. Jury selection, I'm thinking now about jury. It's everywhere. The other thing that I would add, in addition to kind of, thinking at every stage of the criminal legal system process, is also civil commitment. Prianka lifted guardianship, I think, given the public attention to that. We also should look at our civil commitment statutes and the way that they facilitate criminalization. That's state by state law. I can speak to California offline, but another area. I also think in terms of impact litigation, Olmstead claims, risk of institutionalization, social benefits, social insurance programs, and the express disability-based classifications in those laws that will deny people the right to social welfare benefits, professional licenses, parental rights, adoption. So there's a lot, and I know that's very overwhelming, but as impact litigators, I think that the law can be a tool to at least reduce the extent of the harms.
This is Lydia. Thank you so much, Jamelia, for sharing a response that I was hoping you would say something because that person mentioned your article specifically. But I want to thank you, Prianka and Britney, for joining us. I want to make sure to extend gratitude to both of our interpreters who are with us now. That would be Juniper and Tonna, Tonna, as well as to our captioner, Annabelle, to our education and programs assistant, Nancy, who was instrumental in putting together this series, and to all of you for joining us. Please stay tuned for our next webinar, which will be next week on Thursday, same day of the week, but different time, 7 o'clock Eastern, 4 o'clock Pacific. And in that webinar, we will have 3 guests, Finn Gardner, Finn, Gardiner, Agilsa Fernandez, Allilsa, Fernandez, Fernandez, and Angela Lemos Mogrojevo. I'm sorry, I'm fucking up this name and I apologize. This is my fault. Spelled ANGELA LEMUS MOGROVEJO. And they will be speaking on homelessness and disability justice. And you can also register via Eventbrite by following AWN's page. And we hope to see you there. Thank you so much and have a wonderful evening.
Thank you.